Some of our clients at Buscup Law Group ask us, how do I license my invention? And as Wendy Buscup, the managing patent attorney, I say, very carefully, because it involves the client doing work that they might not normally be used to. First of all, they usually have to locate their targets. And one of the easiest way to find someone to license your invention is to look at the United States Patent Office website for a similar invention and see who owns that patent, because they might be willing to give you a license relatively quickly. So you can do searches for similar inventions at uspto.gov to identify targets. Then you need to do some Googles on the targets to find out who is actually going to sign a check to you. Is it the president? Is it the vice president of marketing? Is it the vice president of sales? Is it the long-range developer for the company? It really depends, and you have to do some research to find out who's going to sign the checks. Then you have to develop a term sheet that you would take to a meeting to discuss your invention, along with a presentation of the benefits of your invention, what the invention is, and how the invention will benefit your prospect's company. Meaning, how much will your invention make them in dollars and cents over the next 12 months, over the next 3 years, over the next 5 years. So what are on the average term sheet of the average license agreement? Well, obviously the names of the parties and the addresses, so we get an idea of the jurisdictions that are being dealt with. Then we have to have the description of the invention, which can be an attachment but referred to in the body of the text. And then ownership of improvements to the invention needs to be covered. And then other terms include audit rights for monies paid, the dates of payment, how much is to be paid. Is it a running royalty? Is it a lump sum paid up royalty? Or is it a minimum guaranteed royalty? Sometimes compensation involves a technology transfer fee of $10,000, $15,000, and up to $50,000 just for signing the contract. And that would need to be in the license agreement as well. Of course, secrecy obligations need to be in a license agreement. How long will the licensee be keeping information provided by the licensor confidential, or how long will they keep marketing information, and so forth. Termination clauses, how to get out of the deal if you don't like the licensee, how the licensee gets out of the deal if they don't like the licensor. So termination for cause and termination without cause need to be covered in a term sheet as well. Also, indemnification. What will the owner of the technology do for the person licensing it? Typically our clients, well, we suggest to our clients, don't indemnify anybody. But if you must, then see if you have insurance that can cover any problem that might develop with the technology. There are warranty clauses to consider, meaning, is the owner of the technology going to warrant that the technology performs a certain way or not? And finally, there are issues of what is the real jurisdiction of the agreement. If two companies, one's in Texas and one's in California, which jurisdiction is going to be picked? Is the license agreement going to be inheritable or descendable to a successor of the business? These are questions that are sometimes asked. I hope these informal chats have been helpful, and I've been really pleased to convey some of this information by video for you all. I'm Wendy Buscup, and for more information, look to buscuplaw.com. We're happy to help someone you know patent their invention.